Hi everyone, this is Akshaya Madanagopal. Today we are going to see on the topic traditional knowledge. Traditional knowledge is an inherent intellect or knowledge which is an asset to the native people. It is this knowledge that shapes the culture, identity, and lifestyle of the native people. So, there are more than 50,000 practices, skills, and knowledge which is embedded in the culture of the native people, which forms their traditional knowledge, and this traditional knowledge must be protected by the IP system, and proper credits and recognition must be given to this traditional knowledge. So, first we have to see what this traditional knowledge is and how it is generally protected by the IP system, and what are the improvements that need to be made to bring an comprehensive and better protection for this traditional knowledge. So, first, what is traditional knowledge? Traditional knowledge is defined by the WIPO as a knowledge, skill, practice that is developed, sustained, and passed from one generation to another generation within the community, forming a part of their culture and spiritual identity. So, when a knowledge is passed from generation to generation, which is inherited and forms an identity as an identity of the people, such knowledge is and traditional knowledge. So it is also defined by Article 8J of the Convention of Biological Diversity, which says that traditional knowledge is an awareness, invention, or tradition of the indigenous community which is transmitted orally from generation to generation. So, for example, the wound healing capacity of the turmeric, that is all the turmeric which is used to wound heal, and the neem which is used as pesticides and insecticides by the traditional farmers, and all the sukku melagu tippili which is used to cure cold. All these traditional knowledge and practices which is embedded in the Indian household or the native household is traditional knowledge. What is passed from generation to generation, practiced by the community, is traditional knowledge. So why does this traditional knowledge need protection? So what is the need to protect this traditional knowledge is that there is an increasing demand for commercialization of this traditional knowledge, and there is bio-piracy of this knowledge by big corporations and MNCs. So there is a need to protect this traditional knowledge, and it is not only to protect their knowledge but also to protect their cultural identity. So in order to protect their identity and culture and give proper recognition and credits to the knowledge of the native people, there must be protection of this traditional knowledge. So there is a concept of equity and good conscience, good faith involved in protection of the traditional knowledge. So equity, biodiversity conservation, and preservation of all the healing practices are involved in protection of the traditional knowledge. So there is a great significance in the sustainable development of the world, and there is a great part of the traditional knowledge in development of the world. So protection must be given to this traditional knowledge. So what is the traditional protection or the general protection that is given to traditional knowledge? First, patent. So patent law does not directly protect traditional knowledge. For example, in section 3P, traditional knowledge patent shall not be permitted. So there is no patent shall be given on a traditional knowledge. And in section 2J, only new knowledge or new invention shall be given patent. So the knowledge which is already in existence and already in the community known by so many people cannot be patentable. So patents cannot be given on traditional knowledge. But there is an indirect protection that the traditional knowledge which is embedded in the community stands as a prior art to all the new products. So this traditional knowledge is a prior art to all the new products. Thus there must be no new products that steal the traditional knowledge. So there's an indirect protection, and the Indian government has taken a great initiative by developing an traditional knowledge digital library and traditional knowledge resource classification e-library, all these systems, in order to form a single collection of all these practices, traditional practices, and serve as an prior art to the new products that are brought to market. So the system in which the patent protects the traditional knowledge is a system of prior art system. So prior art, traditional knowledge serves as a prior art, so no patent shall be given upon any new products. So next, going into the copyright protection. Copyright protection shall be given to the traditional knowledge based products and all the artistic works and creations. According to section 14, the section 14 says that the artistic manifestation of the traditional people or the native people shall be protected. For example, the carpentry work, the pottery work, all the sculpture, puppet show, all the musical folklores, all the terukuthu, all kinds of native artwork, art forms, everything shall be protected under the copyright protection, under the Copyright Act. So copyright protection is extended to traditional knowledge. Next, going into trade secret. So even though there is no specific legislation in India to protect trade secret, Article 39 of the TRIPS agreement says that when there is any confidential knowledge, that shall be protected as a trade secret. So when there is any knowledge, traditional knowledge, which is passed as a secret from generation to generation within a family, that shall be protected as a trade secret. For example, only a particular family in Kerala knows how to make these metallic mirrors known as Aramula Kannadi. So in this work of Kannadi, how to make this mirror, only certain people in Kerala know. So this manufacturing process is made as a secret, which is passed from generation to generation, which is passed as a traditional knowledge. So thus this knowledge shall be protected as a trade secret. And next, going into trademark. Under Trademark Act of 1999, even agriculture products and biological products shall be given trademark protection. So all the products and services of the natives can be protected as a whole, as a collective mark, by giving trademark protection. And the quality, the reputation of the good quality products of the natives can be protected. So the products of the native people are protected, the knowledge based products of the native people are protected. Next, going into GI, the Geographical Indication of Goods Act 1999 gives a collective protection for the goods produced by traditional knowledge. So when goods is protected, produced by the traditional knowledge, it shall be protected for its quality and goodwill of the native people. So a collective of GI tag is given for the native people's product. For example, this Kanjipuram silk or the Kalapuri chappals, all this Kolhapuri chappals, all these products are given GI tag, thus protecting the products of the native people. So next, going into the industrial design. So when there is any design or a plan or any method which gives an special efficiency to an product, such design shall be protected. For example, in Lucknow there is this special kadai known as chicken kadai and all, and in this kadai the design of the kadai is different so as to increase the efficiency of the kadai. So this design shall be protected. The native knowledge of making this kadai shall be protected as an industrial design. Now we know all these protection and all. So this gives rise to many landmark cases. For example, turmeric case. In this case, a medicine was derived from the wound healing capacity of turmeric, and this medicine was patented in US. But India opposed this medicine and the patent and called for a re-examination, saying that wound healing capacity of turmeric is used for thousands of years in India as a traditional knowledge, and this shall not be patented. So India also submitted many Sanskrit documents, and US accepted this and ruled in favor of India, saying that the patent shall be revoked. So next, going into the Kani tribes case. In this case, the scientists, with collaboration with the Kani tribes, made an immunity booster tonic from the herb called as Arogya Pacha. So from this herb, from the traditional knowledge of the tribes, they made a tonic which boosts immunity, and this was brought into market and commercialized. And when this was brought, there was an agreement between the tribes and the company saying that certain amount of profit shall be given. So the traditional knowledge was protected by the profit giving system, or the arrangement between the tribes and the company. The next case is the neem case. In this case, the pesticidal quality of neem was incorporated in a product, and this product was brought into market and patented. So neem, a product for pesticide, was patented in US and in Europe. So India opposed this, saying that neem is used as an insecticide for so many years and produced certain Sanskrit documents also. But US rejected this claim and did not rule in favor of India. But Europe ruled in favor of India, saying that yes, neem is in traditional knowledge of India. It is also used for thousands of years in India. Thus, the patent shall be revoked. Next, going into the basmati rice case. In this case, 22 varieties of basmati rice was patented in USA by a company called Rice Tech. In this case, not only the novel quality of basmati rice was given for patent application, but also the traditionally conventionally used quality of basmati rice was also given for patent. And India opposed this and submitted various documents and saying that this type plant variety is already in existence in India and it's traditionally bred and cultivated in India, thus patent shall not be given. However, US did not accept the claims of in India, and there are still various patents on this basmati rice. Next, going into the yoga ruling case. In this case, in 2002, a book was given for copyright protection, a book containing the compilation of various yoga asanas and all the benefits of the asanas. In this case, an NGO put in claim that yoga was an traditional knowledge and it originated in India. Thus, a compilation of all the asanas and all the knowledge of the Indian people shall not be given copyrights. And the US court ruled in favor of the NGO, saying that yes, yoga is in traditional knowledge of India. Thus, just a book of compilation of all these asana cannot be copyrighted. Next, going into the Hodia cactus case. In this case, Hodia cactus is a cactus variety where it is used by the tribes, San tribes in South Africa, as an appetite suppressor. To suppress hunger, this is used. So this knowledge was stolen by Pfizer company, and an medicine was brought and produced. And when this was given for patent, the tribes opposed in the court, and the court ruled in favor of the tribes, saying that even though it is marketed, a certain portion of the profit must be given to the tribal people. So now we can see that there are various problems in implementing all the protection for the traditional knowledge, and some problems are that the traditional knowledge, there are thousands of practices and it cannot be protected unless it is organized or formally recognized. So it is difficult to protect the entirety of thousands of traditional knowledge, and also the native people lack awareness that they are being exploited and their knowledge is being stolen. They lack awareness and means to come forth to file petitions. And even though there is an estimate of $43 billion of medicines which are produced by this traditional knowledge, which is produced by the theft of this traditional knowledge, the only remedy which serves is the legal battle, which is very costly and time extending. Thus, there is no proper protection to the traditional knowledge. So here are some suggestions or solutions to these problems. First is the implementation of the 3 principles of the TRIPS agreement. So TRIPS agreement gave 3 suggestions in order to prevent bio-piracy. So the first is, when the patent application or the IP application is given, there must be a disclosure of the geographical roots of the product. So what is the origin, what is the geographical roots of this this product must be disclosed. And next is the prior consent must be gotten from the local population. So prior consent from the natives must be submitted. Next is the proper benefits or profits must be allocated. A share must be given to the tribal people or the native people for their knowledge. So these three must be first implemented. And the first the patent next is the patent protection is only in the form of prior art system. So there is no proper definition for prior art. So the definition differs from country to country, system to system. So this definition must be harmonized and the international definition of prior art must be given. Next is we must update the traditional knowledge digital library or the forum which serves as an prior art to the new products. So the government must take charge, take responsibility in forming a comprehensive prior art system for traditional knowledge. Next is to create a Sui-generis system of IPR. So separate forum for filing application or separate forum for litigation must be given for traditional knowledge, that is Sui-generis protection must be given. And next is express registration and profit sharing model must be given. The proper legislation and how the profits must be shared, everything must be brought into legal framework in order to give proper protection. Last is the awareness must be given to the native people that they are being exploited, and proper means must be provided to them to make them come forward to file and petition for their rights. Thus, I would like to conclude that this traditional knowledge, which is inherited, preserved, and passed from generation to generation, is the key to sustainable development of the world. It is the gold, it is the profit, it is the rights of the native people, which is a very valuable asset that needs proper protection from the misappropriation and theft by big companies for their greed and for their commercialization and all the monetary purpose. So, proper protection must be given to the traditional knowledge, and also the native people must be given enough support for them to bring their knowledge into market. So when they themselves get their means to bring their product into market, then proper protection for their knowledge shall also be given. So the IP system must be strong enough to give the protection to the traditional knowledge, and the general governmental system must help and support the native people to put forth their knowledge into market. So this is not only for the benefit of the native people, but also for the greater good of the public and for a very sustainable and eco-friendly world. So proper protection, if proper protection is given to this traditional knowledge, there will be a very eco-friendly and sustainable comprehensive development of the whole world and India also. Thank you.